Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. What's up, everybody? We are back at it today with another case breakdown. And today we're talking about Gabby Petito and Brian Laundrie again. For those of you that have been following this case with us from the beginning, it is happening in Florida, and it revolves around two young people who were engaged and went on a road trip across country. The female, Gabby Petito, goes missing. Brian Laundrie ends up back with his parents. Then he disappears. Gabby Petito turns up dead. Brian Laundrie turns up dead. And apparently Brian Laundrie, in some notebook, admits that he is responsible for Gabby Petito's death. And later, a lawsuit ensued between Gabby Petito's parents and Brian Laundrie's parents, where basically Gabby Petito's parents have sued Brian Laundrie's parents for intentional infliction of emotional distress, not keeping them in the loop and telling them what was going on. And basically Brian Laundrie's parents are saying, we pled the fifth. That brings us to procedurally where we're at now, where the Laundrie parents filed their first motion to dismiss, which we thought was going to get granted. Instead, Gabby Petito's parents amended their complaint, and now a second motion to dismiss has been filed. A response has been filed by Gabby Petito's family, and then a reply to that response by Brian Laundrie's parents. So before we get into some of the legal documents, if you're new here, please subscribe to our page and like this video, as it really helps us out. And we do things like this on a bunch of different cases, especially if they're going on in Florida, especially if they get a lot of media attention. If you all have a lot of interest and questions about them, I am going to be going on some local news channels in the coming weeks because the motion to dismiss, that hearing is set for this week. So we're going to keep our eye on what happens here. We're going to talk about this motion. I'm going to ask you a lot of questions as to what you think the state of the law should be when we're talking about tragic situations where we feel like we're on one side and we want justice for Gabby Petito, but we have constitutional protections, we have rights, and we have laws in place that are written a certain way. We've broken down a lot of this before. So when speaking about the motion to dismiss specifically, Brian Laundrie's parents and their lawyers have basically stuck to the same script on the second motion to dismiss. Four corners of the complaint don't work because even if everything the Petitos say is true, they cannot prove intentional infliction of emotional distress. Some of the reasons for that: Brian Laundrie's parents were rightfully exercising their constitutional right to remain silent, not to incriminate themselves by not talking about what happened, what Brian told them, where the body may be, anything like that. All of what they're accused of doing in the civil complaint. They also have the First Amendment right not to speak, which I think is not as strong of an argument, but still makes sense. And then lastly, we talked about the impact rule and how usually in IIED claims, the plaintiff that is filing the lawsuit, which would be Petito's parents, not Petito herself. It's a separate lawsuit. Wrongful death against Brian Laundrie is a separate lawsuit. This is for intentional infliction of emotional distress, basically for not telling them where their daughter was, which I will point out, we haven't heard any hard evidence that they even knew. They're connecting inferences at this point. So we'll see if we end up getting that evidence eventually, and I'll keep my eye on that because that's very interesting. But as it sits right now, all we have are their conclusory statements saying that the Laundrie parents knew and didn't tell them. And does that get past the impact rule? Because Gabby Petito was the one impacted. Gabby Petito had the outrageous conduct against her. And it's longstanding in Florida that family members of people who die do not get to sue other people for additional emotional distress and emotional damages. There can be loss of consortium or certain derivative claims, but not a separate claim of emotional damages or emotional distress. And there's a quote in one of these hearings, one of these motions about it, how that would just create millions of lawsuits and we just can't handle it. So therefore we're not doing it. Doesn't mean there's not emotional distress. Doesn't mean there's not damages. Doesn't mean people are not hurt. I see it every day. The family members are emotionally as distressed as anybody else, including the plaintiff, sometimes even more, especially when you're dealing with parents of children. So it's nothing to belittle those types of claims. Legally speaking, Florida does not recognize them. So that's one of the many problems that we fight about in Tallahassee. But as it sits right now, it doesn't seem like there is a cause of action for something like this. In Florida, the plaintiff also has to be the recipient of the insult or abuse. It has to be directed at them. And the complaint clearly states that there was no contact, and that's what they blame the Laundries for. The Petitos, I'm just going to call them the Petito parents. I realize they're not still together and different last names, things like that. But the Petito parents constantly reached out to the Laundrie parents trying to get information. Laundrie parents did not say a word. So that is no contact. That's nothing directed at them, legally speaking, at this point. And then they also argue that there's no facts in support of causation, meaning what damage was actually caused by them not saying anything. Because they didn't cause Gabby's disappearance or demise. They didn't cause the emotional distress of losing your daughter. But we'll see how the Petitos answered that in their response. The Petitos, again, in their response, go into the fact that everybody realizes this is outrageous conduct. Everybody realizes you shouldn't do this. You can't do this. The Constitution doesn't protect you against hurting somebody like this. And they get into a lot of cases about what's outrageous and what is not. And that's kind of where I want to start showing some documents in this case, because I think it's very interesting. And I think that it is helpful for all of you to understand what is actually necessary to be outrageous conduct. Because we're going to read some of these cases that the court found was not outrageous conduct that definitely seems like it should be. So let me share the screen here. I have no idea if I'm going to get the right one. Yes. Okay, here we go. So this is Petito's lawyers filing in their response to the motion to dismiss filed by Laundrie's parents. In assessing what is outrageous, it is instructive to look at cases in which the court has found or not found outrageous behavior. Here we go. First, these are some cases the court did not find outrageous behavior. Williams, a former employee, claimed that managers as well as other supervisors called him racial names, created a record of false disciplinary incidents so as to justify his termination. The court did not allow, the defendant did not allow him to work with other African-American employees, falsely accused him of stealing, threatened him with job termination for no apparent reason, and had him load or unload aircraft in inclement and dangerous weather conditions, move dangerous heavy equipment and cargo, and work extra flights, thereby eliminating the former employee's break times. By finding that the allegations of the complaint reflected conduct that was reprehensible, objectionable, and offensive, the court found the allegations were insufficient under Florida law to support a cause of action for intentional infliction of emotional distress and dismissal of the plaintiff's complaint. Now, I will mention that under lawsuits like this, sometimes there are still other claims, wrongful termination claims, employment discrimination, things like that can still happen, and they can dismiss just one of the counts, which is IIED. So I do just want to say that just because they dismiss this intentional infliction of emotional distress count does not mean this plaintiff did not have a cause of action. I'm sure there was an employment discrimination, a wrongful termination, a retaliation. I'm sure there were other claims that he or she was allowed to go forward on. I can't remember. It was a he that he was allowed to go forward on. So don't think that there's no cause of action here and that this was okay, right? This is just specifically for intentional infliction of emotional distress to illustrate how difficult and how high of a bar that outrageous conduct needs to be in Florida. All right, the next one, LeGrand. During a church meeting with 250 people in attendance, certain members accused the minister of purchasing a luxury vehicle with money stolen from the church. They further referred to the pastor as Satan or Makout, a name for oppressive secret police from Haitian dictator Duvalier's regime, and stated that the pastor's name means Satan. In affirming the trial court's motion dismissed, the court noted that although we recognize that being branded a thief in front of one's parishioners might certainly be unsettling, embarrassing, or humiliating for a member of the clergy, we do not believe that this alleged conduct is the type of extreme and outrageous conduct needed to support the claim of intentional infliction of emotional distress. Again, doesn't mean it wasn't defamation, doesn't mean it wasn't other things, but not intentional infliction of emotional distress. Next, Ward. The hotel failed to provide a reserved and committed space for a wedding reception, failed to advise the bride and groom of unavailability of the reception room scheduled until the day of the wedding, oh my goodness, and placed the reception in the lobby, which was too small for the 190 guests. There was no privacy, and hotel guests were walking through the wedding reception and participating in the reception. The court found that the bait and switch pulled by the hotel was not sufficiently outrageous to support a claim for intentional infliction of emotional stress. Probably a breach of contract, but not IIED. A lot of people tack on intentional infliction of emotional distress onto another complaint. That's why you're seeing all these dismissals. It's very unlikely and very rare for it to be the only claim in a complaint, which is what makes this case very interesting and very rare. In McAlpin, a patient went to the hospital to have x-rays for a throat ailment. She disrobed and put on a hospital gown and then was directed to the x-ray room. When she entered the x-ray room, the doctor, without warning and in front of other staff, berated the patient for failing to pay the doctor's bill. Doctor refused to conduct the exam and picked up a telephone, threatened to call security and have the patient removed. Patient was unable to respond due to her throat condition and her emotional distress and fled the immediate area clad only in her gown. The court found that the doctor's conduct was utterly reckless and outrageous in a civilized society and would cause an average member of the community to claim outrageous. So this is the first one, because now if you see paragraph 18, we're going to get into the outrageous category. Okay, NIMS. A teacher alleged that 2 students in her class participated in the planning, editing, writing, printing, copying, and distribution of a newsletter publication appropriately entitled The Lowlife. In the publication, the students used extremely offensive language, threatened to kill the teacher, rape her and her children and her cousins. On those facts, the court reversed the dismissal of the action and found the complaints did state a cause of action for intentional infliction of emotional distress. Sheehan, a collection agent on behalf of Ford, after she had been unable to locate the debtor, contacted the debtor's mother and identified herself as being employed by Mercy Hospital of San Francisco, California. The collection agent advised the mother that one or both of the debtor's children had been involved in a serious automobile accident, and the collection agent was attempting to locate the debtor. The mother supplied information to the collection agent concerning the home and business address of the son. On the same day, the debtor contacted the mother. As a result of the information received in that conversation, placed calls during a 7-hour period at the hospital and police departments of California until finally discovered the information was false. On these facts, First DCA said it was outrageous. Woof. Harris, debtor's insurance policy required insurance company to make car payments to the bank, became totally disabled. The debtor became disabled and called the insurance company to honor his credit disability policy, which it did initially, but subsequently challenged the debtor's claims and stopped making payments to the bank. At least twice, the insurance company claims manager called the debtor a cheat and a fraud and attempted to frighten him into collecting the policy. The debtor's case was repossessed. He was forced into bankruptcy and he became severely depressed. The court found that that was outrageous. All right, I skipped a couple examples because we've read a lot of them to kind of get an idea, but I wanted to jump to the one that I feel like was most closely related to this Petito Laundrie case. And I wanted to talk through it. I'll talk about what's similar about it, what's different about it, because this is the one I would hammer on if I was Petito's lawyers. In Thomas versus Hospital Board of Directors, the decedent died at the hospital after having hip surgery and going into cardiac arrest. In the course of treating complications during the surgery, the surgeon gave the decedent a lethal overdose that ultimately led to her going into cardiac arrest, killing her. Therefore, the surgeon and nurses agreed to conceal the real cause of her death and to notify the decedent's family that she died from the stress of the surgery. So they lied to the family about how they actually died during the surgery. This is why we need medical malpractice laws. This is why we need to be protected from doctors, because they can do this. Some bad ones. There's some amazing doctors, but the bad ones can get away with stuff like this. It's not that hard, as you see from this case, but eventually they find out the truth. The cause of death was also provided in a report to the medical examiner and in discussions with other physicians. As a result of the reported cause of death, an autopsy was not completed. However, less than a week later, during the decedent's funeral, the decedent's daughter received a telephone call from the medical examiner demanding that the decedent's body be returned to him immediately for a second autopsy. This demand was made after the medical examiner learned of the real cause of the decedent's death. The court found that the decedent's daughter had sufficiently pled the elements for the cause of action for IIED, and the court went on to state, "We believe that the appellee's conduct in making false statements, which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy, rises to the level of atrocious and utterly intolerable behavior, which cannot be condoned in a civilized community. As noted in Stedman, when an actor has knowledge that the other person is particularly susceptible to emotional distress, the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge." The doctor knew, the nurses knew this was going to make it worse. They did it anyways to protect themselves. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person who would be susceptible to emotional distress and therefore the action of providing false information concerning the loved one's cause of death meets the standard for claim for outrage. So what's similar about that case? First, this statement, we're not going to say this person, but the statements did not cause the death. The statements did not cause the major distress, but they did cause additional distress. Breaking up the funeral, finding out that they actually died by a medical malpractice, having to take them back for a second autopsy when you've already grieved and already gone through that process. So additional damages were caused, were pled. That's what I would focus on if I was Gabby Petito's lawyer. If I was Brian Laundrie's lawyer, I'd focus on the fact that this doctor actually said something, actually lied, actually directed comments at the plaintiff in this case, actually caused those problems and damages by saying and making comments that were lies to this person. No such comments were made by Laundrie's parents. They didn't lie to anybody. They didn't misdirect. They didn't cover anything up with their statements. They didn't insult or say anything nasty to the Petito parents at all, directly or indirectly, frankly. So that's a big difference. So we'll see how the court weighs it. And the judge in this case is Hunter Carroll, who I've been in front of and is an amazing judge. Very smart guy, very good judge. And I'm interested to see what he does in this case. So yeah, they also plead that the Laundrie parents knew that the Petito parents were extra susceptible to distress, which is true because they had just lost their daughter. Let me see if there was anything else I wanted to pull out of this motion here. So they make some more conclusory statements about how no constitutional right gave them the right to not say anything about where Gabby was. They say something like, who does that? Everybody knows that that is a problem. Let me see here if I can find those statements. Do defendants seriously find it objectionable to tell a grieving parent that their daughter is dead and to provide the location of their body? Would anyone find that to be objectionable? In refusing to notify the plaintiff that their daughter was dead and to provide the location of their daughter's body, defendants made a choice. They did not exercise First Amendment constitutional right. I have a major problem with this statement. So literally, they're not saying that any accused criminal has the right to remain silent, that they have to spill their guts and they have to say everything they know, whether or not they were involved in the crime, whether or not they could be criminally implicated. That's just not how the Fifth Amendment in the Constitution works. This is under the First Amendment argument that they make. But as you see, the next argument is the Fifth Amendment. This does not play in our country with the Fifth Amendment right to remain silent. This is exactly the opposite of the state of the law in our country, whether people find it objectionable or not. That could mean somebody could accuse you of something and then just force you to say everything that they can then try to use to incriminate you with something else. Maybe it's not the original crime they thought you did, but now they're going to switch it because they've already got you here. And that can't happen. Yeah, again, they just said they have no right to not tell the plaintiffs whether Fifth Amendment right or not. But let's talk about the impact rule, which we did a whole video on, and they respond to here in about 2 paragraphs very quickly. Plaintiffs must be present. The defense argues incorrectly that for conduct to be actionable as an intentional infliction of emotional stress, the conduct must be directed at the plaintiff and his or her presence. That's wrong according to the Restatement of Torts. One who by extreme and outrageous conduct intentionally or recklessly causes severe emotional distress to another is subject to liability for such emotional distress, and if bodily harm to the other results from it, for such bodily harm, where such conduct is directed at a third person. So sometimes it can be a third person, right? The actor is subject to liability if he intentionally or recklessly causes severe emotional distress to a member of such person's immediate family, which is what we have with the Petitos, right? To a member of the person's immediate family. That is the Petito parents, plaintiffs in this case, who was present at the time, whether or not such distress results in bodily harm. So that second part that they also underlined, that's going to be the important part to pick apart. Peter Piper picked pickled peppers. Because present at the time. They weren't present at the time that anything happened to Gabby. They weren't present at the time that Brian told his parents anything. And they weren't present at the time where Brian's parents didn't say anything, right? I mean, their presence of being alive is not what the law contemplates in being present at the time. So this is a tough one to me. And this is the plaintiff making the argument. In all cases that we have found in Florida, recognizing the tort of intentional infliction of emotional stress, the plaintiff was the recipient of the insult or abuse, which is not the case here, or the message was clearly directed at the plaintiff through a third person. Clearly directed. Was anything clearly directed at the Petito parents? And that's the end of their response. And listen, I think it's horrible what happened. I think if Brian Laundrie actually admitted to this, he deserved to be punished. He's gone now, so there's nothing legally, criminally that we can do to punish him. There is a civil lawsuit suing him for wrongful death. I think they're going to win. I think they're going to win huge. Millions and millions and millions of dollars. They should absolutely win that. That is the correct and proper justification in civil complaint to file. This one is just tough. Not impossible, right? We talked about how Johnny Depp's defamation case was tough, and then he ends up winning. This one is very tough, and it could potentially get dismissed this week again. We're going to keep following it. Let's real quick now look at the defendant's response to that reply. So it's like the plaintiff files a motion, the defendant files a motion to dismiss, the plaintiff responds, and then the defendant replies. It just keeps going back and forth. All right. So outrageous conduct. So the plaintiff cite to cases as examples of conduct found sufficiently outrageous, which is what we just read a bunch of. What these cases have in common is that the defendants therein committed an affirmative act directed at the plaintiff. They are right. An affirmative act. None of them remained silent. None of them decided to do nothing, even though people can say that's an affirmative act, a passive act, whatever you want to say, passive action. But every case they cited, somebody either did something or said something, including that doctor that I thought that was the best case for the Petito family. That doctor and staff said something and lied to them affirmatively. None of these cases found a cause of action entirely based on defendants' inaction. Plaintiffs cite no such cases, and counsel for the Laundries have likewise been unable to find any. Remaining silent and having no contact with the plaintiffs, regardless of the circumstances, is not what Florida law considers outrageous behavior. I tend to agree with this. Now, a motion to dismiss is a very high bar. So the court could allow it to go forward, see what we find in discovery, which is what the plaintiffs argued, saying, Judge, it's early on. Let us show you what we find in discovery. Let us get past the motion to dismiss. And it's very rare that a case gets dismissed this early on. Very rare. If this was a negligence case, I would think 99.9% it's going through. Because it's intentional and because of all of the case law around this cause of act. If this case didn't have the press, if this case wasn't a case everybody's eyes were on and everybody's paying attention to, it gets dismissed, in my opinion. But because there's so much outrage about what happened to Gabby Petito, they want justice for her, they want justice for her family. That's why I think this has a better chance of making it than a normal case under these circumstances. Not to say that it's going to, and not to say that anybody's going to be pressured in the court system. I know Hunter Carroll, the judge, is not going to be pressured. He's going to make the right decision. But I think that all this rigmarole is happening because of the interest in this case. Causation, they didn't make it clear that the anguish increased when they got this news by using terms like increase and prevent to describe how the Laundries caused the distress. It fails to satisfy that element. Constitutional rights, again, they just basically say your conclusions by saying that they can't exercise their constitutional rights are just wrong. They go back and forth and saying this is wrong, this is right, things like that. And then also, there was an interesting okay, here we go. Likely realizing that the Laundrie's exercise of constitutional rights could never qualify as outrageous conduct and is a complete bar to their cause of action, the plaintiffs attempt to weave around that problem by invoking rules limiting the court's ability to consider the issues at the motion to dismiss stage. In doing so, plaintiffs label Laundrie's constitutional rights as affirmative defenses and complain that the Laundries are asking the court to consider facts outside the four corners of the amended complaint. Neither issue saves the plaintiff's amended complaint. What they're arguing here is the Petitos argued that these are actually affirmative defenses, that it was a constitutional right, that it couldn't be this, it couldn't be that. That's not a motion to dismiss. That's a different thing, Judge. Later on, if you want to rule on his motion for summary judgment or the affirmative defense, is fine. We may lose then, but we shouldn't lose now based on this because of the standard for a motion to dismiss. They focused a lot on that on their reply. The defense is saying, yeah, Judge, the reason they're doing that is they're trying to use these technicalities to get over a motion to dismiss so they can harass our clients with discovery. Plaintiffs may be right here, though. They may be right that these are not issues ripe for the judge's decision at this point. Whether or not they were executing their constitutional right or exercising their constitutional right may not be a question before the judge at this point. Maybe the judge should just look at the four corners of the complaint, which is what the standard for a motion to dismiss is, and maybe that gets it past the motion to dismiss and makes it seem to the public like it's a stronger claim than it actually is. Who knows? We'll see. But it seems like both lawyers are on the same page as far as that technicality could get them over the motion to dismiss, even if it's just delaying the inevitable of this case getting thrown out. Let me see if there's anything else I want to hit in this. Okay, yeah, let's hit this last paragraph because they just respond to the impact rule again. Plaintiffs must be present. As the case cited by plaintiffs plainly states, in all cases we have found in Florida recognizing the tort of intentional infliction of emotional distress, the plaintiff was the recipient of the insult or abuse, or the message was clearly directed through a third person. The amended complaint alleges no contact between the Laundries and the plaintiffs, which is true. So plaintiffs received no insults or abuse, nor was any message directed at them. I actually think is true, falls in line with the case law, but it's a motion to dismiss. So it's always interesting to actually look at the court documents, see what these lawyers are arguing, see what the case law is they're using as precedent to build up their case and try to convince the judge to stay in line with what other judges are doing in other cases and what the case law and the statutes are in Florida. We're learning a lot about IIED here. And the reason I didn't go through every word of every one of these documents is a lot of it is repetition from the prior ones with the arguments about Fifth Amendment right, First Amendment right, to remain silent, to not speak about these things. No actions by the Laundrie parents cannot be held against them, and we will see what the judge decides. I do think it's a bit of a scary precedent that you can sue somebody for IIED by exercising their right to remain silent. So that's kind of a scary precedent. Now, listen, there are other claims, and in other cases, like almost every example we read, I promise you there were other claims made, and those lawsuits continued on, just without IIED. And if you're wondering why lawyers sometimes plead intentional infliction of emotional distress, sometimes you can get punitive damages on those awards, which, as we know in the Amber Heard and Johnny Depp case, can end up being millions and millions of dollars. So that's why you don't want to allow that in, because you don't want later for them to be able to come and ask for punitives potentially. But there's all sorts of legal procedures and legal tools that can be used different ways by lawyers. And that's what we try to do on this channel, is break it down, give you a look at it, and say whether or not we think they're going to be successful. And even if I think there's a chance the Petitos get past this motion to dismiss. There is a chance. Much higher chance to dismiss this case than most motions to dismiss. But even if they get past that, it is an uphill battle and will be a very difficult case for them to win on. The opposite is true for the wrongful death case against Brian Laundrie's estate. But this case specifically against the Laundrie parents, I think, legally speaking, is a very difficult case. Let me know what you think in the comments. Let me know if you think they're going to be successful. Let me know what you think about these arguments and whether you agree that this conduct is outrageous or is not outrageous based on the case law. Whatever questions you guys have, thanks for being here. Make sure you hit that subscribe button and like the video on your way out. We'll be back for more next time.